Hello, I'm Casey Welch from Flagler College, and we're continuing the discussion of John Fuller and my book, American Criminal Courts, Legal Process and Social Context. In this chapter and video, we discuss the structure of state and federal courts in the United States. Courts have a pivotal role in the U.S. criminal justice system. They handle 20 million criminal cases annually. And in that process, they have the two functions of crime control and due process. On the crime control side, they must issue warrants, adjudicate cases, and issue sentences. On the due process side, they monitor the police, they monitor the prosecutor as well as the defense attorney, and they sometimes even monitor other judges. This mammoth undertaking, handling 20 million cases and having two different functions of crime control and due process, is made possible because the courts have a narrow and defined set of roles and duties, and because of the jurisdiction system that sets up a hierarchy of specialized courts. But first, let's take a step back and look at the entire court system within the United States. The U.S. is a Federalist System, which means that the federal government has its own lawmaking powers and courts that adjudicate those cases. And then each state writes its own laws and has courts that address those respective cases. The role of both the federal and state courts are defined and limited in two ways. First, justiciability, and second, jurisdiction. Regarding justiciability, courts can't address most of society's problems. They must just sit there. They literally just wait until a ripe case is brought to them. In other words, they cannot hear a case unless it is justiciable, meaning that the court has the authority to hear it. For instance, let's take some cases that are not justiciable. A prosecutor cannot prosecute a case if he thinks that somebody might commit a crime in the future. That's not ripe yet. A prosecutor cannot prosecute a case if the defendant is dead, because that would be moot. An appellate court cannot address a case or a law that they think might be unconstitutional until that case is appealed. So they just have to sit there. They cannot issue an advisory opinion. Jurisdiction, the other limiting factor and guiding factor of the courts, is the authority of a court to hear a case or some particular aspect of a case and adjudicate on it. The jurisdiction question generally revolves around the subject matter of a case. There are two kind of main subject matter questions. First, is it a federal or state issue? If it's a federal question, federal courts will hear it. If it's a state question, the respective state court will hear it. The second question is it original jurisdiction or appellate jurisdiction? Original jurisdiction courts hear the case for the first time. These are called the trial courts. Appellate jurisdiction courts, they hear questions of law that are brought up during the trial. So the jurisdiction, these two sets of courts, they create a hierarchy of courts that specialize in certain duties and types of cases. A case will be assigned to a particular court based on the nature of the dispute. So if the case in front of the court is this person guilty of armed robbery, an original jurisdiction court will hear it. If the case is, did the police follow proper procedure while interrogating the suspect, that will be heard in an appellate court. The appellate courts themselves are divided into two layers, which are the intermediate court and the high court. The intermediate court hears the first appeal. The high court in the federal level, which is the U.S. Supreme Court, hears the case for the second time if the losing party appeals to the higher court. The state high courts have different names. Some of them are called Supreme Court, but they also have other names. This structure and this issue of justiciability and jurisdiction are very stable. They've been in the United States for 200 years. But an emerging issue in the courts, one that is only a few decades old, is the issue of specialized courts. And this is discussed in a later video and chapter. But a couple of examples are drug courts, community courts, teen courts, and also courts that hear cases involving defendants who are veterans of the military. These courts are considered problem-solving courts because they focus on a particular problem. The advantages, and a lot of people like these courts, the advantage is that they bypass some of the formalities of law in order to kind of cut to the chase, to solve the problem quickly, to get the job done, people argue. They adjudicate a case quickly, they mete out punishment quickly, and ideally they reduce recidivism. But the problem is precisely the solution. The problem is that they are, in fact, bypassing due process protections. And they operate, for instance, under a presumption of guilt. Somebody must admit to being guilty prior to entering into this system. And the judges and prosecutors are granted a lot of unchecked power, much more so than a regular trial court. So ultimately, what these do is they expand the power of the criminal justice system. The U.S. is going to move in the direction, more than likely, the U.S. is going to move in the direction of more specialized courts. However, as civil libertarians and people, advocates of civil liberties, address the problem of minimize or reduce due process protections, it's likely that these courts will start having provisions that protect the rights of the accused. So, in summary, our courts have a stable structure based on justiciability and jurisdiction. However, there are emerging issues that we're going to face in the upcoming future. Thank you, and I'll see you in Chapter 4 when we discuss criminal law and trials.